Good morning, welcome everyone to our second conference day. After the excellent presentations and discussions that took place yesterday, we begin a new day, and very possibly, after having tested absolutely positively the affirmations of our hosts about the very good things of the city of Girona. It is really a great honor and a pleasure for me to introduce our first speaker, Professor Ronald Allen. Professor John Henry Whitmore of the Law Faculty of Northwestern University, with a long list of publications both in Spanish and English, Vice President of the Rules, Procedure and Evidence Committee of the American Bar Association, currently President of the Board of Advisors of the New Evidence and Forensic Science Institute in Pekin, and with a number of presentations and opinions, is going to be giving us the first presentation. Professor Allen, you have the floor.
Thank you for that kind introduction. It's a great pleasure to be here among old friends and former students, and a distinct honor to be addressing such a distinguished collection of evidence scholars from around the world. I should say something as a preliminary matter in advance before I begin my talk. My work is positive, not normative. My self-conception, maybe self-conceit, is that of a scientist, not a philosopher. So I'm not quite sure why Jordy invited me to a World Congress on Philosophy of Evidence Law, but I want to be clear that my objective is to understand what I observe, not to moralize about it. Once you understand what you observe, then normative thinking can take place more efficiently, so that's fine, but that's not what my objective is. My title will be heard by various participants here in a different way. It will not sound strange at all to our Chinese colleagues who conceive of the study of evidence precisely in these terms, and who have created the International Association of Evidence Science that holds quite successful biennial conferences that blend together what in the Anglo-American world we would call evidence, scholarship, and forensic science. It may sound a bit odd to the Europeans here for the reasons I just identified, who tend to approach questions of evidence from a more philosophical than empirical perspective. But I suspect it will sound oddest of all to the Anglo-American scholars in the room for two reasons. The first is the lingering effects of the attack by the legal realists in the first half of the 20th century on the alleged pretensions to science by their doctrinal predecessors that led to the term legal science becoming something that no self-respecting legal scholar would admit to pursuing. Quite remarkably, even the rise of law and economics, which is by far the most important development in the Anglo-American legal world in the 20th century, did not scrub this term of the disdain heaped upon it by the realists. The second reason this may be, that this may sound a little odd, may be the recent disappointing results of a multidisciplinary effort at identifying the components of the integrated theory of science. Notwithstanding the optimistic tone set by a very distinguished intelligence analyst, actually, who was interested in evidence law, David Shum. The scope of that effort was not limited to law and legal systems, and was motivated by the thought that perhaps there are commonalities in the concept and implications of evidence across different disciplines that could be synthesized. In the words of one of our distinguished participants here, William Twining, quote, "The idea of a shared enterprise that also focused on some shared general questions was lost sight of. My personal hopes were not realized. The development of a new subject matter is a major undertaking." Well, why do I raise these things? Well, I suspect that there's a common reason for the lack of success in both these enterprises, and to wit, that is that one does not make a science top-down. One becomes aware of sciences as they grow up around you. Moreover, quote, "sciences," unquote, are unruly, and as far as I'm aware, and I don't claim to have an encyclopedic knowledge of all sciences, none of them can be easily characterized by monolithic descriptions of either subject matter or method, even at the most banal level. As an example, take the king of science, physics, with mathematics seems to be the queen. As an example, such references almost always are to a small subset of physics, particle physics, where there has been stunning success, in large measure driven by its mathematical underpinnings. But there are other branches of physics that lack this conceptual purity, such as fluid dynamics, those involving nonlinear physical electromagnetic phenomena that exhibit chaotic effects beyond the competence of mathematicians to tame. No physicist, imagine that there is a particle of water somewhere here, an atom, a molecule of water, H2O, and there's not a physicist in the world that does not think that where that particle of water, that molecule of water is going to end up is completely determined by physical forces. Everyone believes that, and no physicist would think that would be a worthy question to examine, because it's not possible to tell where any particular molecule of water will end up. It's subject to too many chaotic and interacting enterprises. Now, of course, there are many other sciences that have achieved remarkable successes without being tied to the hip to mathematics in the way that particle physics has been. Biology, for example, and neurosciences are other examples. There are a lot of examples that can be given. The telling point for my purposes, though, is that no one set out to create particle physics or biology or the neurosciences in their present form. Rather, they grew up around practitioners pursuing more or less common aims with more or less compatible methodologies. So here's the burden of my talk today, and that is that there is a science of evidence that is evolving as it applies to legal institutions. What I mean by legal institutions are the methods and modes of governance in a representative democracy, the only form of governance within my competence, really. With at least a modest commitment to the rule of law, you can have stronger or weaker commitments to the rule of law, of which legal systems and dispute resolution are an important point, an important part. Now, I realize these are simple definitions, but I believe they will prove adequate to the task. What I mean by science is equally naive, but like naive realism, it may be better than its more sophisticated cousins. What I mean by it is a systematic study of some more or less common phenomena from a more or less common perspective using more or less compatible methodologies. And evidence science has grown up around these legal institutions that tends to focus on various forms of dispute resolution, but has much wider implications than that. Although virtually no one, to my knowledge, presently engaging in this science thinks explicitly in these terms, and I'm not saying that they do, I'm saying this is what they actually are doing. In fact, we are collectively engaging in a subset of the study of complex adaptive systems. I will briefly describe complex adaptive systems, demonstrate that collectively this captures in an important way what we are studying, and then conclude with some thoughts as to whether or not, even if I'm right, the recognition of what we are doing has any significant consequences. Maybe it doesn't. Maybe it's just pouring wine into different bottles. I actually don't think that, but we'll see. A critical difference exists between something that is complicated and something that is a complex adaptive system. And this is actually one of the key points. Something that is static is compared to something that is dynamic. A good metaphor being the distinction between a tree farm, is what you see here, and a rainforest, what you see there. It's sensible to ask what the point of a tree farm is. It is not sensible to ask what the point of a rainforest is. The difference between a static system and a dynamic system. The distribution of grains of sand on a beach is complicated, as is the progression of a hurricane, but neither are complex adaptive systems. Chess is complicated, but static. Go is complicated, but static. These are closed deductively, and the rules are complete. Complex adaptive systems, by contrast, involve massive discrete interactions, emergent properties, and often involve feedback mechanisms. Examples are the immune system, traffic on roads, the progression of infectious diseases, and as I shall return to later, in this discussion, elections, markets, and responsive legal systems. And I think the paradigm of a responsive legal system, but it's not the only example of it, is the common law. Again, these are dynamic. They change. They're not static, deductively closed. As a consequence, unpredictable consequences emerge. And let me be clear, these are examples and generalizations. There's no universally accepted specification of the meaning of complex adaptive system, the phrase complex adaptive system. The study of complexity is a science that is emerging in precisely the manner of its objects of inquiry. Indeed, even the meaning of complex is complex, a useful description that captures the essential concept of complex adaptive systems across many different disciplines, in the word of Melanie Mitchell, a distinguished complexity scientist actually at Caltech, is this. It's a system in which large networks of components with no central control and simple rules of operation give rise to complex collective behavior, sophisticated information processing, and adaptation via learning or evolution. Neil Johnson, a more popular writer, but quite good on these topics, identifies complex science as the study of phenomena which may emerge from a collection of interacting objects that can arise in the absence of any controller or coordinator. There are precursors to these ideas that include both the Hayekian distinction between made and grown systems. Price theory is another example for if there are any economists out here. And the concept of autopoiesis that was first penned by two Italians, Umberto Maturana and Francisco Varela, to refer to the self-sustaining nature of cells, and extended to social systems, including legal systems, most famously by Nicholas Luhmann. Now, in an important sense, and this is a critical point, a complex adaptive system is more of a frame of reference than a natural kind. Conceptualizing the immune system as a complex adaptive system is completely uncontroversial. It obviously is one. But it is also true of the human body, which is also a complex adaptive system, of which the immune system is a part. And so too with the surrounding ecology, of which the human body is a part. The most spectacular complex adaptive system may be the universe as a whole. From a single and singular quantum event, we get stars, galaxies, giraffes, and immune systems, with the human mind being perhaps a close second. The idea of complex adaptive systems is thus in part an empirical tool whose payoff is in the work that it can do to advance understanding. Now, nothing guarantees that a complex system, will adapt in a direction that a participant in a system may view as beneficial. Dinosaurs, had they thought about the matter, were probably not all too pleased with the aftermath of large meteors striking the Earth or stupendous volcanoes erupting that made life decidedly unpleasant for them. However, these same processes laid the groundwork for the age of mammals so far as we can presently tell. The human immune system keeps the average person alive, notwithstanding, and it's stunning when you actually hear these kinds of figures, a constant assault from trillions of pathogens, some of which are quite threatening. And yet at other times the pathogens prevail, which, you die, which the pathogens might think is a good thing, but you probably wouldn't. Because of the evolution of the human brain that has allowed the species to control to a considerable extent its environment, humans are not entirely at the mercy of nature, obviously. One of the consequences of this capacity to control the environment is the possibility of exploiting the benefits of complex systems, and that's where complexity science comes into being. And there's one potential benefit that looms large. There are lots of benefits, but one that overrides all the others. And that's the capacity of complex adaptive systems to process vast amounts of information without a top-down central controller, without anybody doing any computing, because you couldn't. It's called computational intractability. Evolution's an example. Evolution as a system contains almost an infinite amount of information. The The human species or any other part is the product of close to, as I say, infinite number of local interactions that led to the emergent property of life, what we call life, and then speciation. The immune system is another quite stunning example. With no central command, nobody's telling your T cells where to go, like go down to your toe and check out that infection, or go to your lung and see if maybe there's a precursor for cancer. No one's telling these T cells where to go, yet it does a remarkable job of keeping us alive in the face of the onslaught noted above. Now, a remarkable example of this is, this is a picture of us evolving this and that, that I want to use as a metaphor is the centrifugal governor invented by Thomas Watt to regulate the rate of a flywheel attached to a steam engine that was critical to the success of the textile industry in Britain, which in turn fueled the Industrial Revolution, which in turn laid the groundwork for you having the lives that you have today. Now, here's the problem. To spin fine thread, you need a constant and controlled source of energy. The steam engine provided the energy, but it was episodic. You'd put more coal on or whatever, more wood, the fire would heat up, the steam engine would go faster, then you'd try to slow it down, it'd slow down too much, and you get bunched up threads rather than fine threads. So the first solution to this, let me go to my next slide actually, the first solution to this was to attach it to a flywheel. A flywheel is just a heavy mass that goes in a circle and smooths out inertia. Now that actually helped. But still, the steam engine is subject to all kinds of variables, how much heat there is in the heating system, how fast it's burning, the external environment, the pressure on it, all kinds of things. And this wasn't good enough for the spinning of fine thread. Again, you could get coarse thread, but not fine thread. So Thomas Watt came up with this idea, and that actually did lay the groundwork for the wealth creation of the Industrial Revolution, called a centrifugal governor, where he realizes he could attach these arms to a spindle, and as the flywheel goes faster, what happens? The spindles separate. As you slow it down, they come down in this manner. Now, what's the advantage of this? Well, you can control the speed of a flywheel in a computational way. This is what you would have to do. You measure the speed of the flywheel, compare it to what you want to get the thread that you want. If there's no discrepancy, return to step one, and guess what? Continue repeating that forever. A costly process. If there is a discrepancy, then you measure the current steam pressure, calculate the desired change, calculate the necessary valve adjustment, make the throttle a valve adjustment, and return to step one again. This is a computational solution to the problem of uniform power coming out of a steam engine. This is extraordinarily costly. You'd have to have people standing there all day at every steam engine doing this. And you still would get lumps because there would be a gap between the time at which these computations were taken and the adjustments that were then made. So what does the centrifugal governor do? Well, this is actually quite stunning. Whoops. Wrong button. What this invention does is it allows almost the instantaneous transmittal of almost an infinite amount of information from the flywheel to the spindles to the throttle in a two-way street. So you have massive amounts of information being almost instantaneously communicated, that you just adjust the flywheel so they stay there. If they go faster, if the spindle so they stay there, if the flywheel goes faster, they start to go up, and then they close the throttle until they go down again, and in reverse. It's a stunning achievement of the taming of a massive complex problem by a very simple solution. Timothy Gelder thinks this is perhaps a metaphor for thought. I'm not going to examine that proposition, but what I do want to point out is how this employment of a complex adaptive system actually led to the wealth of Western Europe and the United States. Now, take this metaphor and generalize it. Humans can exploit these phenomena of complex adaptive systems by the creation of cognizant feedback mechanisms to attempt to guide emergence. And there are at least three that, in my opinion, help explain, along with many other variables, I'm sure, the success of the Western world. And they are the three I mentioned earlier: elections, markets, and the common law. Again, the common law, I don't want to get anybody's hair up on the back of their neck. I mean by the common law simply a responsive legal system, and you actually have some in Europe, in particular in the northern part of Europe, but there you are. These three permit the intelligent exploitation of vast amounts of information. Much too much information for any central command or control center to process and act upon. This, of course, is Hayek's central insight about price theory, but it applies to markets generally. It's not just information about price that markets are accommodating, but also consumer desires and needs. Elections do something quite similar because of the feedback mechanism of, we say, kick the bums out, elect somebody new, which is certainly salient to our Spanish colleagues here today, as you just kicked one of those bums out, realizing kicking the bum out is a term of endearment, just not of criticism. Responsive legal systems do the same thing. The paradigmatic example is the common law, but there are others. In fact, the common law is both an example of adaptive systems that can accommodate large amounts of information, and an example of how intelligent systems can evolve in the absence of a central control mechanism. No one thought up the law in the common law. As Matt Ridley, another person who writes in this field, says, it's a code of ethics that was written by nobody and by everybody. It's a beautiful example of spontaneous order. He continues, and I quote, "Judges change the common law incrementally, adjusting legal doctrine case by case to fit the facts on the ground. When a new puzzle arises, different judges come to different conclusions about how to deal with it, and the result is a sort of genteel competition as successive courts gradually choose which line they prefer, and in this sense, the common law is built by natural selection." This is true of any responsive legal system. It's not just the common law. If your legislatures are responsible not just to elections, but to its constituents, you have the same kind of feedback mechanisms that can allow adjustments to occur. Now, Ridley is not a lawyer, and he leaves out three important parts of the story, all involving feedback mechanisms that assist the system to process information in an intelligent way. Appellate judges, legislatures, and citizens. Appellate judges act to facilitate this competition by providing competing perspectives on whatever the question is at hand, and legislatures can intervene whenever there is the political will to do so. The critical variables of the common law are information processing and responsiveness. And again, you can get that in other versions of the legal system than the common law. And in particular, small homogeneous democracies with a strong commitment both to the rule of law and responsiveness to constituents. Now, what about other citizens? In my opinion, this is the most important but least noted attribute that makes a responsive legal system like the common law work as well as it does. When a decision is reached, it ripples out across a complex neural network structure formed by the citizens of the pertinent jurisdiction, and anyone with an interest in it can become aware of it. This is a picture of the internet, but it's also the picture of social interactions. In fact, this picture of social interaction would be more complex than this because you interact in other ways than the internet. But what this looks like is the human brain with neurons with thousands of axons spreading out across this network, interacting in just untold complex ways. Well, that's social interactions generally. And why does it matter? Well, a decision comes down, it ripples across this complex neural network structure formed by the citizens of the pertinent jurisdiction, and anyone with an interest in it can become aware of it. A decision may be helpful to some, and such people can work towards its adoption or exploitation. The same decision may be harmful to others, and they can work toward its constraint or elimination. Both activities can be through further litigation, agitation for statutory change, social protest, or whatever. All these messages likewise traverse the network, causing perturbations in the system, which facilitates the examination and probing of the issue in question by vast numbers of individuals with varying perspectives, knowledge, and background, and not a single control mechanism. Whatever happens, happens. And again, messages go out across the network in iterated fashion until some form of stability, not an equilibrium, but some form of stability, at least localized stability, is achieved. All this is facilitated in the common law by the principle that the judges only decide the facts and arguments presented to them. But that could be the same as a responsive legislator who will consider any new arguments made by a citizen when the citizen thinks the legislation or the legislator has made a mistake. If a first decision is reached that did not consider what a third party to the litigation thought to be important or determinative, the next judge or court can consider this. It should also be immediately obvious that appellate decisions in legislature have these same network effects. All three ripple through the system, engaging the cognition of others in the system and allowing responses. Now, all of this is a bit stylized in today's world that is the culmination of more than a century of increasing statutory and regulatory intrusion into private lives. But core elements remain true. Legal systems can be more top-down or bottom-up. They can be more or less responsive to nuance, and they can be more or less tolerant of discretion. And admittedly, there are pitfalls everywhere. Rules have strengths as well, in particular in view of the demand to treat like cases alike. Discretion can be wisely administered or arbitrarily. But analogously, it can be the case that the rules themselves are what become arbitrary, where there's a distance between the letter of the law and its spirit. Rules become oppressive in part, and this is part of the message here, because of their inability to respond to dynamic contexts. Again, the distinction between static systems and dynamic systems. Another advantage of viewing legal processes through the lens of complexity is to highlight the significance of this distinction between static systems, where rules often work fine, and dynamic systems where they don't. Now, halfway through my talk here, what does any of this have to do with the law of evidence? In my opinion, quite a lot, as I will now try to demonstrate, and I will attempt to show that understanding of the object of much of the inquiry of the people in this room is enhanced by looking at that object through the lens of complexity theory. Many of us in this room, in fact, probably just about all of us, I'm an exception, but I don't know how many people like me there are, view the evidence as involved primarily with advancing accurate outcomes subject to certain policy constraints. And thus the field of evidence is associated primarily with epistemology, echoing the statement from Bentham almost 200 years ago that the study of evidence is the study of knowledge. This is true to a considerable extent in both his world and ours, and for a very good reason, and it's a stunningly important reason. Efficiently and effectively establishing the facts at trial is critically dependent upon the field of law, upon the field and law of evidence, and without accurate decision-making, I won't elaborate this point, but without accurate decision-making, rights are meaningless. There's this view that the political side of the Enlightenment was by far the most important aspect. I don't think that's right. The epistemological side of the Enlightenment was at least as important, if not more so, than the political side. I mean, not only are facts necessary to the protection of rights, I mean, rights are utterly critically dependent on fact-finding. Without orderly decision-making, errors cannot be allocated consistently with political preferences. But they're complexifying factors that the facile equation of the field of evidence with epistemology neglects. I mean, this is what most people think about evidence, right? Epistemology, the significance of facts, how we get to knowledge, although no one at trial in the American system is actually interested in knowledge. They're interested in mistakes, but not knowledge. But the law of evidence does much, much more than structure an epistemological episode. That's point number one that I'll elaborate here in just a second. And point number two is that theories of evidence are contingent political constructs in very important ways. Now, the first point, the complexity, the direct complexity point. Consider the complex objectives of the law of evidence, at least in my world, the Anglo-American world. People from other countries can think about this from their own perspective, which the field of evidence, not necessarily the law of evidence, but often the law of evidence, has to accommodate in some way. In addition to epistemology, the law of evidence accommodates at least 4 other variables. The first is actually critically important, and that's the organizational problem. In addition to structuring the context of fact-finding, the law of evidence regulates the interactions of the various participants in the legal system. Trial judge, jurors, if you have them, and lay assessors, but not just them, attorneys, parties, witnesses, both lay and expert, and constructs the framework for a trial. It allocates both power and discretion to each of the actors. For example, by determining how much discretion the trial judge has, the law of evidence affects how much control the parties have over the process. Similarly, the law of evidence structures the relationship between trial judges, or in your case, trial in the first instance, trial in the second instance, and appellate judges. Should there be trial de novo in the appellate court, or is appellate review limited to the resolution of legal errors, which essentially insulates from appellate review factual decision in the trial court? Are small civil cases different from large commercial cases in ways that justify different treatment? What's unique about criminal cases? The law of evidence also regulates the relationships among branches of government. I don't know that you've thought about that, or many of you have, but it's obviously true. Once you think about it, whoever writes the rules at least partially determines the outcome. So you have the rules of evidence actually regulating the relationship between legislatures and courts, not just courts and parties and each other. Let me give you an interesting example of this. The European Court of Human Rights has handed down a bunch of opinions mandating confrontation rights in criminal cases. These rulings take power from courts and local legislatures and locate it in parties. It's now the party that gets to make the decision as to the presentation of evidence, not your local legislature, not your courts in a common law system. There's another problem, the governance problem. Notwithstanding the importance of accurate fact-finding, there are other goals in addition to sensible trials that accurate fact-finding competes with, and often through the creation of incentives of various kinds. The list of social policies that conflict with accurate adjudication is long and very culturally contingent. For example, the law of privileges may foster and protect relationships like spousal, legal, medical, spiritual, governmental, and others. In addition, perhaps settlement of disputes is preferred to litigation for cultural reasons, which leads to the exclusion of statements made during settlement costs. In the United States, more and more in the world at large, a body of exclusionary rules is premised on the perceived need to regulate police investigative activities. The important point here is that the legal analysts cannot limit attention to the epistemological question, the legal evidential analyst, for epistemology competes with social policy. One important policy is the satisficing, I would call it optimizing, but my more technically oriented friends say I should call it satisficing, of the 4 possible outcomes at trial, which aren't just 2 mistakes, they're also 2 correct outcomes, which itself adds a complexifying variable that I'll return to below. But there's more. There's the inoperable PowerPoint. There we go. The social problem. In some societies, not all, but some, trials serve additional functions to dispute resolution, such as symbolic and political purposes. Both institutions and individuals can make statements through the means of trials and impart lessons of various kinds. Trials can also be the means of vindicating reputations and obstructing government overreaching. Obviously, the law of evidence impacts these issues. Principles of fairness and equity may also influence the law of evidence, although the precise effect of this variable is often hard to sort out from more overtly utilitarian motivations. But some think that the limit on unfairly prejudicial evidence reflects not only the concern about accuracy, but also the concern about humiliation, as is the case with character evidence rules as well. The limits on prior behavior and propensity evidence reflect in part, although by the way, the limit on prior behavior and propensity evidence and character evidence is way overstated. The American rules on character evidence are more rules of admission than exclusion. But we can talk about that if you like, but in any event, they, to some extent, reflect the belief that a person should not be trapped in the past. The hearsay rule reflects the values of the right to confront witnesses against oneself, and so on. And then one last point, and that's the enforcement problem. There's a critical distinction between rules on the books and rules in action. It's one thing to write rules and laws, it's another to enforce them in the way anticipated by the drafter of those provisions. And the drafter of a code of evidence may think a rule has a precise meaning, or that allocating discretion to someone, whether trial judge or attorney, makes sense. But the drafter may have in mind an approach to interpreting the rule or exercising that discretion that might not be shared by those implementing the rule. More generally, it's hard to enforce complex codes in social events such as trials. The event itself, the trial, is often fluid and unpredictable. And it would be impossible to have every decision at trial second-guessed by some other authority. And the field of evidence has to determine how to respond to such matters and incorporate those conclusions in the law of evidence. This catalog of complexifying evidence is not complete. It admits, for example, the complex interaction of substantive law on the one hand and procedural and evidentiary law on the other, and there are surely other variables that escape my attention. The police in the United States wanted to stop cars, to be able to stop cars. They say randomly. The risk is that randomness equates or turns out to be, in fact, capricious or arbitrary. And the Supreme Court said, no, you can't do that. There's too much of a risk of arbitrary, and in particular in our case, racial discrimination. So what's the response to that? The response to that is to make it impossible to drive in the United States today without violating a law. And that's what the vehicular code does. All you have to do if you want to stop a car is follow it. You will get too close to the center line, too close to the curb, it won't put on its turn signal at exactly the right time, and now you can stop it, and there's no examination into the intent of the officer in stopping. If he had probable cause, he had probable cause, no matter what his actual intent was. So the substantive law wiped out this aspect of the procedural law. In any event, there probably are other variables that have escaped my notice, and I'm sure my presentation is decidedly parochial and associates the field of evidence with contemporary thought in Western democracies. Unfortunately, life is again more complicated than this. To be sure, the law of evidence emerges from the field of evidence, and one ought to distinguish the field of evidence from the law of evidence, but it does so by implicitly adopting or furthering a theory or set of objectives of litigation. Theories of litigation are themselves derived from more fundamental understandings of the nature or objectives of legal systems. But legal systems are derived from even more fundamental theories or objectives of government. These are all interconnected, and the field of evidence cannot neglect the point. Evidential reasoning occurs in a context. It has universal attributes, in my opinion, like cognition and the nature of rationality, although that's a more contested concept. But it has also idiosyncratic components fashioned from the community in which it resides. So one sees a bubbling cauldron of complexity that the evidentiary scientist has to deal with. The more abstract one's lens, moving from mundane questions of admissibility to governments and legal systems, the more obvious it is that the object of inquiry is a complex adaptive system. Consider just one example, one last example of this that I mentioned above. There's this fetish, I would call it, preoccupation, others might call it, being more polite, with the focus on mistakes at trial that seems to preoccupy, as I say, students of burdens of persuasion. No sensible social planner, however, would look just at mistakes at trial, but instead would expand the horizon to include both correct decisions and the associated mistakes and cognate procedures as well as the adaptive effects on primary procedure. So here's what, we talk about errors in the legal system, but what's the real problem? The real problem is that you do have errors at trial, but they also affect settlement, and there can be errors at settlement. Settlement's done in the shadow of the law. So the social planner, you have at least these two things to think about. And you also have cases that aren't settled, don't even get into the litigation system because, again, of decisions made in the shadow of the law. All this is within what should be thought of as errors. And you're trying to optimize these, but that optimizes at most litigation behavior. The point of the law isn't to optimize litigation behavior. Correct decisions matter too. Like I said before, there are 4 decisions that can be made at trial, 2 errors and 2 correct decisions. And in any event, the real concern is the effect of all this and the interactive effects on primary behavior. Now, that's the problem that the legal evidential analysis analyst should be dealing with, in my opinion, when it thinks about errors. So the promise of fair and accurate findings at trial gives citizens and government incentives to follow the law, as do the transaction costs of litigation. It's often a pointless waste of resources to dispute ownership of property, for example, if it's predetermined in advance. This creates strong incentives to talk among ourselves about disputes, determine where we disagree, and work out equitable resolution, rather than waste social resources on litigation. So the cost of litigation, which is often viewed as a problem, is in some part socially useful in giving people incentives to structure their affairs to avoid it and to reduce overall transaction costs, reduce the overall transaction costs of all this, because again, that can be a waste of social resources. The field of evidence can't limit its horizon to just the legal system, and this is what I've been saying, but it has to take into account the more general social contributions that the legal system makes to society. The law of evidence is a critically important tool to implement these social objectives, but surely this is an adaptive process. As the law changes, both litigation and primary behavior changes in response. Conceptualizing the law of evidence as involving a static rather than a dynamic process obscures these important components of a sensible field of evidence. At a more discrete level, trials themselves are adaptive, at least surely in the American and Anglo-American system. Trial judges make rulings both out of fidelity to the law as well as a desire to avoid reversal, and for other reasons, impulses that can be in a complicated relationship. An even clearer complication results from the desire on the part of the judge to follow the law and the desire to effect an outcome that the judge surely thinks is just, but whatever. The parties, however, have a wide range of options to respond to trial judges' behavior and to each other, and which can then reverberate across this set of relationships, prompting further moves in one direction or another. Even the basic concept of relevance has to be seen through the lens of complexity rather than through the rather sterile lens of doctrinal analysis. The standard doctrine taught, at least in American law schools, that relevancy is determined by whether a reasonable person would conclude that an offer of evidence increases or decreases the probability of a fact of consequence, a material proposition at common law, is at a minimum quite unhelpful. You heard it here first. This is the standard idea, but it is a minimum quite unhelpful and in fact probably just wrong. Any offer of evidence at trial can be conditioned upon any other offer of evidence at trial that has or will be made. At the time of offering of evidence, one simply has no clear idea what its role will be once all the rest of the evidence is admitted. Evidence that a person was observed near the scene of a murder increases the probability of guilt until evidence is admitted that he was visiting his dying mother in the locale, as he always does at exactly that time, until evidence is admitted that the times of the 2 observations were different, until evidence is admitted that at least one of the timekeepers was malfunctioning, until. Perhaps the best example of this analytical problem is a criminal case with an alibi, for which the standard understanding of relevancy literally makes no sense. The prosecution's case is completely irrelevant and should not be admitted if the alibi is true, and vice versa. The alibi evidence should not be admitted if the case for the prosecution is true. This leads to a correction of the conventional views of the law of evidence when viewed through the lens of complexity. Often the only thing that can be determined at the time of admission is whether or not evidence furthers a party's explanation of events, as exemplified by an alibi. But both parties get to give their explanations in their own terms. And thus, in the typical case, and you can check this yourself by reading transcripts, the evidence at trial is massively overlapping. Most witnesses after the first on a particular topic largely repeat what has already been said. If the conventional understanding of the meaning of relevancy is true, all that relevance is irrelevant because, in the words of Federal Rule 401, it does not have any tendency to make the fact of consequence more or less probable than it would without the evidence, and thus should be inadmissible by reference to the exclusion of irrelevant evidence. But of course it isn't. The conventional understanding articulates a sufficient but not a necessary condition of admissibility, as does the furthering of a party's explanation. Returning to whether or not approaching these phenomenon from the perspective of complexity theory is of any use, as we've already seen, it is least true that viewing the evidentiary process as a complex adaptive system helps clarify a number of important issues concerning the nature of juridical proof. Its significance goes much further. It also explains a paradigm shift that is presently occurring concerning the understanding of juridical proof from the probabilistic paradigm that has dominated Western thought to an explanationist paradigm that involves the analysis of the explanatory alternatives offered at trial. The probability paradigm is first of all, the probability paradigm is incredibly valuable, important, and insightful, so I want to be clear about that. But it began to be undercut by a recognition that trials were too complicated to be handled appropriately. This is the well-known problem of computational complexity. Additionally, no satisfactory interpretation of conventional probability could be given in the absence of plentiful and reliable relative frequencies, which don't exist very much. So, and while true, these critiques of the probability paradigm were not the deepest problem. The deepest problem is the probability paradigm accurately explains virtually nothing that occurs at trial, from the initial admission of evidence, as I just explained, to its processing, which can't be done, to the ultimate conclusions that are reached, which can't be probabilistic. Explanationism, by contrast, does, although it's a loose explanation. Evidence is admitted, and this is just a descriptive account of what's actually occurring, and now you can critique it once you see it is probably true. Evidence is admitted if it forms part of a party's explanation. Evidence is processed not in an updating way. This is the biggest mistake that's made. Trials are not an updating process. They're an educational process in which the fact finder is educated by the party's explanations and in which all the cognitive tools in the cognitive tool chest are available, including probability. The alibi problem noted above goes away because each side gets to provide its explanation. Subject to few nuances, the conclusion is reached in civil cases by deciding which explanation is more plausible, and in criminal cases by deciding if there is a plausible story of guilt, and if so, whether there is a plausible story of innocence. A lengthy exegesis of this theory, it's come to be known as the relative plausibility theory, will be published in January in the International Journal of Evidence and Proof. With 20 or so, many of you in here have been invited, 20 or so commentators. And as is typical with paradigm shifts, there are objectors, resistors, and answers, and we will give answers to these objections. I don't want to belabor this, but I do want to say one thing. We can talk about the relative plausibility theory later after it's published and so on and so forth. But given the audience, I do want to emphasize one matter. The evolution of this idea is obviously, I hope you see the connections, prompted by thinking about complex adaptive systems. Explanations are adaptive versus algorithmic. But the evolution of this has been associated with another idea, which is the psychological story model. And indeed, 30 years ago, the consanguinity of the two seemed to yield support to both. However, relative plausibility has no necessary analytical relationship with the story model, and the failure to recognize that has been misleading. The early psychological research, like the early analytical legal work, focused on criminal cases and torts cases, in which there are indeed usually are stories in classic chronological form. But the trial of disputes ranges far beyond these simple examples. There are not stories in the typical antitrust case, nor in many contract cases, nor in no-fault divorce cases, or in disparate impact cases, and so on. There are, by contrast, explanations in all of them. Now, viewing the litigation process through the lens of complexity theory also points to the future of evidence science, in my opinion, and that is to empirical work done with complex adaptive systems in mind. Interestingly, there's important work being done now. Again, I'm not sure anybody doing this work thinks in these terms, but there are at least two obvious branches where I think once you look at it this way, you can see the impact of complexity. That's the very interesting artificial intelligence branch of evidence science, the people interested in argument structures, scenarios, and the like. And the related, more philosophical side is the argumentation theory that seems to be important in Europe. I don't know if you've ever noticed this, but nobody in these fields agrees with anybody else. Now, why is that? Well, the reason is what they're dealing with are complex adaptive systems. Spinning out the arguments in one case turns out to not be very predictive of the arguments in the other. You can see sometimes basic structures, but those basic structures are not rule-like. They don't have to be followed in the next case, and if the next case is different, it's different, and so on. Now, do I have 2 more minutes or not? Should I done? I do have 2 minutes?
Yes, please.
All right. So as I say, I have no idea if you people doing argumentative theory or Flora Spex and Douglas Walton and Bart Vahai, Henry Prack, and these others who do scenarios and so on think in these terms, but they are in fact exploring the ways in which people reason in adaptive situations. Their disparate results, as I just said, are also indicative of the underlying dynamic that they are studying, which resists reduction to simple propositions and simple deductions. A good friend of mine, Dale Nance here, who probably rejects most of what I say, has just published a recent explanation of what he thinks is going on at trial. The interesting thing about that explanation is it too is demonstrating that the conventional probabilistic paradigm is wrong, and he substitutes for it something else. But even though he does that, at a critical moment he says this, talking about arguments that are made, that they serve important functions relative to both the assessment of discriminatory power, the ability to make a probability statement about truth or falsity of propositions, and the choice of what he calls Keynesian weight, how much weight the evidence has versus how much it discriminates against between two different propositions. And he says plausible reasoning serves as a tool for the analysis of evidence in common sense terms. Even as litigation comes with ready-made contending hypotheses, C and not C, these general claims typically will be refined at trial to specific theories of the case, one or more of the claimant insisting C, and one or more for the claimant instantiating not C. In deliberation, though, the fact finder will often find it necessary to consider other alternatives, and as Peirce noted, Charles Peirce, abduction or inference to the most plausible explanation becomes a critical tool by which common sense reasoning develops such additional hypotheses. An assessment of Keynesian weight must be made relative to the contending hypotheses, and as they change, some modification of the practical optimization of Keynesian weight and so on becomes necessary. Remove the references to Keynesian weight, and my co-conspirators and I that have been developing this theory, this area, I don't call it a theory, would completely agree about this. Another distinguished member here may or may not agree. William Twining, in an Italian passage, quoting Bentham, as it turns out, but I think quoting him sympathetically, says this: to find infallible rules for evidence, rules which ensure a just decision, is, in the nature of things, absolutely impossible. But the human mind is too apt to establish rules that only increase the probabilities of a bad decision. This is exactly right. Precisely because rules are often ineffective tools in dynamic environments, as, for example, in the legal context, whether they're designed to control the admission of evidence, its processing, or the inferential process. What's this have to say about the future of evidence science? So I need to wrap up here. Well, maybe not very much. It's at least explanatory of both doctrinal points and a significant paradigm shift discussed above. It also explains other attributes of evidence law, such as the interesting shift from epistemic rules of exclusion, and provides justifications for furthering that development. Viewing things through the complexity lens, in addition, points to the kind of work that I think will be most fruitful. That work will attempt to accommodate the dynamic nature of the systems under inquiry, such as evidence law, the field of evidence, litigation theories, theories of government, rationality, and so on. Such a mode of thinking may lead to the extension work that we do in other areas as well. For example, I hypothesize that human flourishing will be found at the intersection of well-functioning markets, free elections, And when I say the common law, at least a responsive legal system. Each of these involves a complex adaptive system that permits extremely complicated information about human preferences to affect the structure of social systems in a way that leads to human flourishing. At this point, I'm not sure I can prove or disprove this hypothesis, and we can discuss why if you like. But it's for precisely the reason at the heart of this talk. The concept of human flourishing is complicated and contested. The three variables identified have complex interactive effects, and there are countless other pertinent variables as well, although my present view is that they are less significant, but I don't know. At the end of the day, there may lie in wait the accusation, which is always a problem in work like this, of the creation of a just so story. You're just creating a just so story. These are daunting obstacles, but also exhilarating challenges, and one might think that enterprises with a low risk of failure may not be worth the effort. And if I can emphasize that point to you, the young scholars out there, I would say it again, that enterprises with a low risk of failure may not be worth the effort. One might wonder one last time what all this has to do with the law of evidence. I have two responses, although maybe not a good answer. The first is that I see questions of evidence all over the landscape of this hypothesis. The second is that, and I hope no one will object too strenuously, I'm an evidence scholar, and this is where my research program has taken me. Thank you very much.
Thank you, Professor Allen, y tenemos todavía tiempo para discutir.
So we have some time for discussion now.
Professor Twining.
First of all, congratulations on a stirring and wide-ranging performance. Secondly, just one minor correction. I don't think David Shum's work is top-down. He's very concerned with cross-fertilization between different disciplines and different decisional contexts, and it's very much the middle order and sometimes even less abstract thing. Whereas I think applying complexity theory in this grand way that you've done is much more top-down than the Shum enterprise, but that's not my concern. I want to ask you to clarify a little bit about what you said about relevance. I get a picture from your talk and your paper that you are somewhat trial-centric and litigation-centric, but you're not committed to your science of evidence in law is not committed to only thinking about evidence in litigation contexts. But there is, by concentrating on the trial, when a lot of other decisions in litigation that also involve evidentiary issues, sentencing, parole, decisions to prosecute, police investigation, and so on, all involve decisions which, to some extent, involve inferential reasoning from evidence. But you sound as if you're dunking the concept of relevance, both within the litigation context and beyond it into, for instance, people drafting contracts, anticipating events, and so on. But surely relevance is absolutely key concept in your own approach to the law of evidence and evidence in law.
The end? Is that the question? Yeah, so words are complex, and relevance can mean one thing in one context and something else in some other context. So the phenomena that you're talking about, that is the effect that we think some datum has on our reasoning about some probandum, is of course significant across lots of different ranges. The focus here was trial-centric and meant to be trial-centric. I mean, the beginning, not the end, but the beginning of a discussion of this relative plausibility concept that explains trials better than probabilism. So in other contexts, sure, evidence means different things in different contexts. And the concept of relevance you're talking about surely is pertinent across many different disciplines, not just many different aspects of the legal system. I agree with that. That's why I say the word can mean lots of different things in lots of different contexts. But to put it precisely, our federal rule that defines relevance in probabilistic terms is just false. It's falsified by experience, and that's the point I was making here. That does not bear on other events where you are interested in relevance in the sense that you mean that. But even there, Bill, I don't know your system, but I know ours. Even there, those presentations in most of those contexts are not ex parte, they're adversarial. And there's no a priori regulating or controlling or looking at the relevance of evidence in the sense you mean it. But parties can produce completely in opposition proffers of evidence, both of which can't be true. The trial judge doesn't a priori say, well, I'm excluding that because if that's true, this can't be, and if that's true, this can't be. No, they hear both sides in just a way that's highly analogous to what I was talking about here, the explanations that are offered at trial. So I think the point that I was making does have wider ramifications, but I also think one can think about the relationships between data and proposition in lots of different ways, and I think it's going to resist the creation of top-down theory that I thought you all were looking for at University College London a couple of years ago.
Sí.
Gracias, Professor Allen. Ricardo León.
Thank you, Professor Allen. Ricardo León from Peru. Yesterday we had a very interesting session and you were present. We talked about many things linked to expert evidence. And in my case, I was rather concerned. I tried to participate, but I didn't have the chance. There was no time regarding this possible knowledge of judges about the current scientific discourse, because as you told us, indeed, in many systems are very complex, and knowledge, in order to be able to actually understand and resolve, is going to be complex as well, and let alone the developments of a number of hard sciences in recent years that seem to show that many of the things that we took for granted in the past are false nowadays. So my question is, what's your opinion on whether judges indeed are kind of trained into some kinds of scientific speeches or scientific updates about the kind of most recent scientific discoveries, but can judges have a real understanding of these discourses in order to efficiently solve real cases?
So, yes, thank you for that question. So, I don't think it's possible for judicial training, that is generalized judicial training, to put judges in the position to be able to handle whatever scientific evidence comes along. I think that actually inverts what the problem is. We should think about the problem from the other way around. What are the deepest aspirations for trials? Now, again, this may be parochial, and you tell me if it resonates with your understanding or not. But the deepest aspirations for trials in the Anglo-American system is that a disinterested, unbiased decision maker is presented with evidence that that person or persons can understand, can process, deliberate on, and then reach a reasoned judgment, best that they can reach about what happened. Now, when you think about that as the deepest aspiration to trials, what you see is that expert testimony, the way it's presented, at least in the US, and I think even more so in the continent, is a real reproach to that. You're admitting this alien form of speech that cannot be understood, processed, and deliberated upon. That's the conceptual problem that my work in this field of experts has focused on, more than anything else, pointing out the conceptual conflict between the use of expert testimony and what our deepest aspirations for trials are. Now, what's the solution to this? Well, there's no single shot solution to it. I think either Jordi or Tarufo yesterday was saying we should advance forensic science. Yeah, we should, absolutely. But the more general solution is to say to the parties, you can't produce evidence unless you can explain it, unless you can make it comprehensible to whoever the fact finder is, whoever the decision maker is. Now, actually, your system would be preferable because the judge can be more active in saying, well, I don't understand this, I don't understand that, explain this to me, explain that to me. If you put the parties in the position of having to justify their own admissions, I think what you would see is a burst of human creativity that would advance that process. You don't need to make a judge or a jury, and remember, it's a jury. There's a lot of demeaning thinking about individual jurors, but the issue isn't in this context whether every juror understands oncology or econometric studies or whatever. It's whether the group does. If there's a single decision maker or judge, it's whether the judge does, right? Right. Well, if I can't explain my evidence adequately so that you, the judge, understands, or you, the judge, thinks is a good prospect the jury collectively would understand, you shouldn't admit the evidence. Now, to which you might say, well, that means a lot of things can't get tried. Well, now I go back to the deepest aspiration of trials. If there are questions that can't be resolved consistent with what we think trials should do, they shouldn't be resolved in that context. Now, that would be a radical change in the United States, because it's essentially saying that legislatures should provide legislative solutions to problems that can't be resolved in this fashion, and thus the trial lawyers, which are very powerful politically in the United States, will object to this, and thus it won't happen. But analytically, that's what I would say. So now I can't guarantee you, sitting here, right, this isn't a rhetorical discussion. I can't guarantee rhetorically that judges will be able to be put by adversaries into a position to understand, but that's the direction I would go in because I think it's probable that they can, and again, human creativity is stunning when given opportunity to play.
Yeah, good morning, Professor. My name is Renato, and I'm from Brazil. Excuse me because of the simplicity of the question, but as you told about the theory of explanationism, in Brazil we have, that I know, one person that's developing an approach of this theory in criminal proceedings. And I congratulate you for the excellence in the provocative debate here in the article, and as you told, but you told in some passage here that epistemology competes with social policy. And I noticed in the article that it would be critical in the vision of Professor William Twining and also Professor Dale Nance, but you told a lot of things about the shift of paradigms, but I would like to know if it's really necessary nowadays to have this shift of paradigms, because probably it's a misunderstanding of my part, but it seems to me that the epistemology is not sufficient to cope the situations nowadays with the complexity of the systems, at least of what I have read here. I want to hear a little bit more, because it's not clear if it's really this, the epistemology model is not sufficient to cope with the situation, and why do we need this shift of paradigm?
So, that's a very interesting question. So this paper, this talk is operating at two different levels. It's operating at a very general level, and then as I try to give an example of the power of viewing things through the complexity lens, which is a discrete example. And that discrete example has to do with the role of probability theory in trials, which has mostly been debated on epistemological grounds. So I think the disjunction is between the generality of the approach that I wanted to take generally, and then the example, which is considerably more discrete than that. By the way, I wasn't criticizing Twining or Nance. I was actually congratulating them on coming along for the ride. In the probability context, in the case of the way we think about, this is almost all focused on burdens of proof, which I think, as I said, is not the right way to think about it in any event, because you have to think about decisions that are made in the shadow of trial, not just at trial itself. So, you know, what cases are deterred from being brought to trial because of what the rules are. You know, there's an enormous effect on primary behavior because of changes in litigation behavior. I mean, a good example of this is electronic evidence. Electronic evidence is a great idea, and it turned out, you know, it's almost costless to store vast amounts of information. But in our system, we have what's called discovery. When you have a trial, and now the other side asks for all the emails pertinent to this litigation, you might be talking about trillions of emails, which costs billions of dollars to go through. And so there's this interactive effect of primary behavior and litigation behavior. But the debate about relative plausibility is very discreetly focused on the best understanding of burdens of persuasion and the effect that that has on the admission of evidence. So that's all I was talking about. The probability paradigm, look, for 200 years, it's been assumed that probability is the right language to discuss trials and juridical proof in. In the legal academy, John Kaplan wrote a famous article in 1968, and that started the literature, the academic literature on probability, which again more or less assumed that this is the right language to think about these issues with. And it was powerful. I mean, let me be clear. The probability paradigm was very powerful, very insightful, very interesting. But then what happened is irritants started to arise. By the way, I mean, I've always wanted to be part of a paradigm shift, so that's why I'm presenting it this way, ever since I read The Structure of Scientific Revolutions. So here we are in a paradigm shift. But irritants, in just a Kuhnian sense, started to develop. That, you know, there are computational complexity problems, the problems of the conjunctive effect. But then there were deeper problems that started to emerge along the lines I articulated. Most evidence at trial is massively overlapping, regardless of what happens elsewhere. At trial, it's massively overlapping. That should all be, if you took the rules of evidence seriously, should all be excluded. It's irrelevant. Well, it's not. Why? Because that explanation of the admission of evidence isn't very good. Evidence at trial cannot be processed in a Bayesian way. The computational complexity problem destroys that hope, but it's deeper than that. You have no idea what the conditional dependencies are, the conditional probabilities are. You just literally have to make it all up, which is not a very good prescription for accuracy at trial, and so on. So it's in this context where what we're saying is, and you know, Bill can call it top-down if he likes, I don't really care, there's a better explanation. And the better explanation is explanationism. What you see happening at trials is parties are offering their explanations. Fact finders, for the most part, are choosing over those explanations in terms of plausibility, which is more plausible. Probability plays a role in assessing plausibility, but it's probability arrived at through plausible reasoning. Fact finders can make up their own stories, and I hate to use the word stories, it's explanations. And if they think that's the most plausible thing that occurred, that's what they'll find, and they'll adjudicate accordingly. In criminal cases, what we see happening, you know, people talk about there has to be a high probability of guilt. Well, you know what? If there's a single story on the table, a single explanation, and that explanation has evidence supporting it, and there's no other alternative offered, that's a high probability of guilt. That's the dog that didn't bark in Sherlock Holmesian thinking. So these are all resolving this, are directed towards resolving this one problem, which is more epistemological than anything else. So that's the disjunction between the general discussion and the specific example that I gave. But think about the example of errors. We talk about errors all the time, right? And we talk about errors at trial all the time. How can we limit our analysis that way? It's as though the legal system were a thing apart and we're trying to optimize it Well, you're not, I don't think. No sensible person would. You would try to optimize social welfare. And social welfare involves the interactive effects between primary behavior and litigation behavior.
Tenemos unos minutos para una última pregunta. Profesor Papayanis, arriba.
Muchas gracias. Buen día.
Thank you very much. I think that in general, I do agree with many of the remarks and the observations that are done in the work in relation to the substantive law and the evidence law. But I would like you to point out something else about the trial and the cost in trials at an optimum level. When we impose costs to the parts, we avoid longer trials, but sometimes litigation can be lower than the optimum. And I think when there are micro damages, for instance, and this avoids a social change, or at least it makes it a little bit slower. So that could be the first part of the question. And the second question is a little bit less important. And I'm talking about the human flourishing, the well-functioning markets. This idea you were talking about, well-functioning can work, and the social assistant can be also a component for the human flourishing. And the conditions in which markets do work would make for a communist system also to work. I mean, if we take into account preferences for people, then we can planify everything and we can even get to a free market. So I would agree with free elections and a good legal system. But the third, I think it's much more controversial. If we think in how resources are developed, I think this is much more controversial. So I don't know whether you can say something.
I told we haven't got a lot of time. But your very interesting question would take a long time to answer. On the latter point, I don't know of any communist system in which markets have worked. It's not. China is the one example held out. China is not a communist system. China is a dictatorship, an oligarchy, but it's a capitalist system. So, FYI. On the first point, the economists have demonstrated a very important point, which is that there are optimal levels of different things. There's an optimal level of criminality. There's an optimal level of cost of wrongdoing. Why an optimal level? Because to get any more out of the system would cost more than it's worth. And I think that's an important way to think about it, and I think you're suggesting that. And it may be the case that you or I think that there's a too low a level of criminality, or too high, not too low, but too high a level, or whatever. I mean, we may disagree with that, but that is a contribution the economists have made long ago. But what we're adding to it is the system effects of a change. That you might think that the costs of litigation are too high, and so you lower them. Well, what happens is you get much more litigation than you want, or as a possibility, that the system again adapts in unpredictable ways to the intervention. And I don't have any algorithms to solve that problem, but that's the way that I think you need to think about it.
Bien, thank you very much, Professor Allen. Gracias a todos y los invitamos a un café.